Welcome back! Today, we're diving into one of the most important Supreme Court cases you've probably never heard of. It's a story that starts with one farmer, but it ends up completely redefining the power of the U.S. government.
Now, this sounds like a classic David versus Goliath story, right? But trust me, the outcome is probably not what you'd expect. It all kicks off with a single farmer, a field of wheat, and a fight that goes all the way to the top. 239 bushels. That's it. This is the number at the absolute heart of everything. This tiny amount of wheat, grown by one man for his own use, is what sparked a constitutional firestorm that, honestly, is still burning today. So, how on earth did this much grain cause so much trouble?
All right, so let's meet the man at the center of it all, Roscoe Filburn. He owned a small dairy farm out in Montgomery County, Ohio. And to really get what this whole fight was about, you first have to understand his life on that farm.
Now, the most important thing to get about Roscoe Filburn is that he wasn't some huge corporate wheat farmer, not even close. He was just running a typical small family farm. He had dairy cows, he raised chickens, he sold milk and eggs. The wheat he grew, that was almost entirely for his own use, feeding his animals, making flour for his family, and getting seed for the next year's crop. It wasn't meant for the market.
Okay, so here's where it all goes wrong. Under a new federal program, the government told Filburn he was allowed to plant exactly 11.1 acres of wheat. But what did he do? He planted 23 acres, almost double his limit. This gave him that excess harvest of 239 bushels, and for that, the government hit him with a fine of $117. Filburn looked at that and said, "No way, I'm not paying it."
And you're probably thinking, why in the world does the federal government in Washington, D.C. care about one farmer's extra wheat in Ohio? It seems completely nuts. Well, the answer isn't really about the wheat. It's about the fact that the entire country was in the grips of the Great Depression.
So, Congress had passed this law, the Agricultural Adjustment Act. The whole point was to try and get the national economy under control. The theory was, if you could just control the supply of major crops like wheat, you could stop the wild price swings that were absolutely wrecking farmers' lives.
And make no mistake, the problem was huge. I mean, look at this. In the 1920s, a full quarter of all American wheat was sold overseas. Fast forward to the 30s, and that export market has just vanished. It's less than 10%. This means there's a massive glut of wheat in the U.S., which was just crushing the price for everybody. So the government's grand plan was to manage the national supply by controlling it at the most micro level imaginable, farm by farm. They decided that to save the national market, they had to tell every single producer what they could and couldn't grow. It didn't matter how big or how small you were.
But Filburn wasn't having any of it. He sued the government. He argued they had absolutely no right to penalize him for wheat that he wasn't even selling. And just like that, a fight over a small fine on a small farm exploded into a huge constitutional showdown about the very limits of federal power.
It all boils down to this fundamental disagreement. Filburn's side is simple. My wheat never left my property. It never crossed a state line. This is a purely local activity, and you, the federal government, have no say in it. But the government's argument was much broader. They said, it doesn't matter that it never left your farm. The very fact that you grew it affects the national market price for everyone.
The whole legal battle revolved around this one sentence in the Constitution, the Commerce Clause. It gives Congress the power to regulate commerce among the several states. But what does that actually mean? Courts have been arguing about that phrase for over 150 years. Roscoe Filburn's case was about to push that definition to its breaking point.
So this was the million-dollar question for the Supreme Court. Does federal power stop at the state line, or can it reach all the way down into a single farm regulating crops that you grow for yourself and never even put on the market?
So, what did the court say? Well, their decision didn't just end the fight for Roscoe Filburn, it introduced a brand new and incredibly powerful idea into American law.
The ruling was unanimous, and this one line from Justice Jackson's opinion says it all. He's basically saying, sure, on his own, Roscoe Filburn's extra wheat is a drop in the bucket. It's trivial. But, and this is the big but, when you take his actions and combine them with all the thousands of other farmers doing the exact same thing, suddenly it's not so trivial anymore.
This became known as the aggregation principle, and it's the core of their whole logic. You can think of it like this. One farmer growing a little extra wheat is a puddle. But thousands of farmers across the country all doing it at the same time? Well, that's not a puddle, that's a flood. And a flood can absolutely affect the entire national economy. The court's reasoning went like this. Every bushel of wheat Filburn grew for his own livestock was a bushel he didn't have to buy from the market. So in a way, his homegrown wheat was competing with wheat being sold commercially. And if thousands of farmers all do that, it reduces the overall demand for wheat, which pushes the national price down, the very thing the government was desperately trying to prevent.
And this decision went so much further than just Roscoe Filburn's farm. It dramatically changed the balance of power in America, basically reimagining just how powerful the Commerce Clause really was.
See, before this case, courts were always getting tied up in these little semantic games. Was an activity production or commerce? Was its effect direct or indirect? The Wickard court just swept all that off the table. They said, forget the labels. The only question that matters is this. Does this activity have a real, substantial economic effect on interstate commerce? If yes, Congress can regulate it.
The legacy here is just immense. This decision became the constitutional foundation for some of the biggest federal laws of the 20th century. Things like the Civil Rights Act of 1964 were partly justified by arguing that local discrimination, when aggregated, had a negative effect on the national economy. Environmental laws, workplace safety laws, so many things were built on this idea that if a local activity adds up to have a big national economic impact, the feds can get involved.
The court also made one last crucial point. They said, look, our job isn't to decide if this law is a good idea or if it's fair. That's a political question, and those questions belong to Congress. The court's only job, they argued, was to decide if Congress had the constitutional power to pass the law in the first place.
And so, the case of Roscoe Filburn's 239 extra bushels of wheat leaves us with this huge, unsettling question that we are still debating today. If nearly any local economic activity can be bundled together with others to claim it affects interstate commerce, then what, if anything, is actually beyond the reach of federal power? Where do you draw the line? This case opened a Pandora's box of federal authority, and we've been arguing about what's inside ever since.